I woke up to the sound of heavy machinery tearing apart the shoreline behind my house. By the time I ran onto the back deck, part of my fence was already gone. 3 contractors were standing inside my yard. A hydraulic pile driver was hammering thick wooden posts into the lake bed. A skid steer had crushed through my landscaping, and stacks of lumber were scattered across the patch of grass where my father used to sit and fish. Then I saw the sign, Lake Briar HOA Community, Dock Authorized Construction. There was just one problem. I wasn't a member of the Lake Briar HOA. I had never been a member, and the land they were building on belonged to me. I shouted for the crew to stop. Before anyone could answer, a woman in white pants and an expensive-looking blouse marched toward me from the shoreline. Linda Carver, president of the Lake Briar HOA. She didn't apologize. She didn't ask permission. She pointed toward my own backyard and told the contractors to keep working. When I stepped in front of the equipment, Linda actually threatened to have me removed for interfering with an HOA project from my own property. I went inside, grabbed my deed, and came back out. Linda barely looked at it. The HOA approved this shoreline years ago, she said. That deed doesn't change anything. Then, she pulled out her phone and called the sheriff. She reported me for trespassing. For several seconds, I couldn't believe what I was hearing. The woman standing inside my yard, beside workers who had removed my fence and driven construction equipment across my lawn, was telling the sheriff's office that I was the trespasser. 2 deputies arrived while the pile driver was still sitting 20 feet from my house. Linda immediately handed them a neighborhood map. Someone had drawn a yellow boundary line across it, placing the strip of shoreline behind my house inside what she called HOA common property. Then I handed them my recorded deed. The documents did not agree. The deputies refused to decide a property dispute on someone's lawn, but they ordered the crew not to continue until the boundary could be verified. I thought that would finally end it. It didn't. As the deputies headed back toward their patrol cars, Linda turned to the contractor. Then she looked directly at me. "The police aren't stopping this project," she said. "We'll finish the dock." That was when I stopped arguing. I pulled out my phone and started recording everything. The missing section of fence, the tire tracks, the machinery, the lumber, the workers, Linda, and every orange survey stake that had suddenly appeared across my yard. Then I noticed something near the trees. An old iron survey marker had stood there for as long as I could remember. My father had shown it to me when I was a kid. It marked one corner of our property. I walked toward it and stopped. The marker was gone. There was a small hole where it used to be. The dirt around it looked freshly disturbed. 23 feet away, closer to my house, stood one of Linda's new orange stakes. I stared at it for several seconds. Then I checked another corner. Something was wrong there too. At that point, this wasn't just about an HOA building a dock without permission anymore. Someone appeared to be changing the boundary itself. I photographed everything and made one phone call. Not to Linda, not to the HOA, and not to the sheriff. The person I called arrived the next morning carrying equipment Linda clearly hadn't expected to see. She came outside almost immediately. At first, she was angry. Then she saw where he placed the first marker. And for the first time since this started, Linda stopped talking. Because whatever she thought those orange stakes proved, the ground was beginning to tell a very different story. And we hadn't even reached the shoreline yet. I was never the kind of person who wanted to fight with an HOA. Most of my life had been built around avoiding unnecessary conflict. I worked as an electrical technician, kept to myself, paid my bills on time, and preferred fixing things with my hands instead of arguing about them. The house on Lake Briar was the one place where I never felt like I had to prove anything to anyone. My father had bought the property in the late 1980s, long before Lake Briar Estates existed as the polished subdivision it had become. Back then, the road was narrower, the lots were larger, and there were more trees than houses. He built the deck himself, planted 2 dogwoods near the water, and spent years slowly turning the shoreline into a place where our family gathered on weekends. When I was 12, he taught me how to cast a line from that bank. When I was 26, we rebuilt the old wooden steps leading down to the lake. And when he died, that stretch of shoreline became the one part of the property I could not imagine giving up. I eventually bought the house from his estate and moved in permanently. By then, most of the surrounding acreage had been developed into Lake Briar Estates, with stone entrance signs, uniform mailboxes, landscaped medians, and an HOA board that seemed to have an opinion about nearly everything visible from the street. My lot was different. It had been created before the subdivision, and my deed did not place it under the HOA declaration. I was not a member. I did not pay dues. I did not vote in their elections, use their clubhouse, or ask them to maintain anything on my property. That distinction had never mattered much until Linda Carver became HOA president. Linda believed every property around Lake Briar should look like it belonged to the same community, whether the paperwork agreed with her or not. Over the years, I received polite-looking emails about my mailbox, the color of my storage shed, the location of my fishing boat, and even the fact that I sometimes parked my work truck beside the garage. I answered the first few. I explained that my property was outside the HOA. Then I stopped responding. For a while, that seemed to be the end of it. But the tone changed after the board announced plans for a community dock. Lake Briar had become more crowded, and residents wanted additional boat access. The HOA already owned a small common parcel along the water, but it was steep, rocky, and difficult to reach. Building there would require more excavation, longer stairs, and a much larger budget. My shoreline was the opposite. It was flat, open, and easy to reach from the neighborhood road. A few months before construction started, Linda came to my house and asked whether I would consider selling a narrow strip of waterfront to the association. She framed it as a benefit to everyone and suggested I would barely notice losing it. I declined. I did not need the money, and I had no interest in turning the quietest part of my property into a gathering place for dozens of boats and residents. Linda never asked again. Instead, I started seeing references in HOA newsletters to a future dock with improved community shoreline access. At one board meeting, posted online, Linda claimed the association had reviewed its access rights and was moving forward with a location that would best serve residents. I remember reading that sentence twice. Something about it bothered me, but there was no parcel number, no site plan, and nothing that directly mentioned my land, so I assumed they had found another location. That assumption was my mistake. What I did not know was that while I was going to work, mowing my yard, repairing the old deck, and trying to live the same quiet life I had always lived, someone was apparently redrawing the meaning of my property behind closed doors. My father used to warn me about that kind of thing in a way I never fully understood when I was younger. He would point toward the tree line separating our land from the future subdivision and remind me that fences could rot, signs could move, and people could forget. Paper did not forget. If you have ever dealt with an HOA that acted like confidence was the same thing as legal authority, tell me in the comments what happened. And if you enjoy stories where ordinary homeowners use documents, evidence, and patience instead of shouting matches, like the video, share it with someone who owns property, and subscribe so you do not miss what happened when I finally opened the records my father had kept for decades. Because after the crew showed up in my yard, I went looking for those records, and buried in an old file cabinet was a survey I had not seen since my father was alive. The crew came back the next morning before 7. I knew because my security camera sent an alert while I was still making coffee. When I pulled up the feed, I saw Mark Voss walking through the gap where my fence had been removed, followed by 2 workers carrying a bundle of treated lumber toward the lake. By the time I reached the backyard, the situation had already gotten worse. One of the dogwoods my father had planted had fresh cuts along the lower branches. A section of landscaping stone had been pushed aside to make room for equipment. Deep tire tracks crossed the grass. Stacks of lumber, metal brackets, and dock hardware were sitting inside my yard like the property had already been converted into a construction staging area. I told Mark again that he did not have permission to be there. He barely looked concerned. He said the HOA had authorized the project, the site had been approved, and any boundary issue was something I needed to take up with the board. That answer told me everything I needed to know about how they planned to handle this. Nobody was going to stop voluntarily. I called Linda. This time, she did not even pretend there was uncertainty. She said the association had a legal right to use the shoreline because it served the lake community. When I reminded her that my deed included that land, she shifted the argument and claimed there was an access easement. I asked where it was recorded. She avoided the question. A few minutes later, she changed the explanation again and said the lake itself was a shared amenity, which supposedly meant residents had a right to reach it from the most practical access point. The most practical access point happened to be my backyard. That afternoon, I received an email from the HOA demanding that I stop interfering with the dock project. The language was dressed up to sound official, but what caught my attention was the threat at the bottom. They claimed I could be held responsible for construction delays. The next day, another message arrived with an invoice for almost $4,000. It listed labor downtime, equipment delay, and rescheduling costs. I stared at it for a long time. An HOA I did not belong to was trying to charge me money because I objected to strangers building on my land. I responded once. I stated that my property was not subject to their declaration, that I was not a member of the association, and that I did not recognize any authority they had to assess fees against me. After that, I stopped debating them. But Linda did not stop. At the next HOA meeting, she told residents that one adjoining homeowner was blocking access to an improvement the entire community had paid for. She described the dispute like I was trying to take something away from the neighborhood. Within days, I could feel the difference. People who used to wave while driving past my house stopped doing it. Someone left a note in my mailbox accusing me of acting selfishly. A neighbor I barely knew asked why I thought I should control so much shoreline when everyone else had to share the lake. That part bothered me more than I expected. Not because I needed everyone to agree with me, but because Linda was turning a property dispute into a character judgment. She was making me look unreasonable while construction continued. Then the orange stakes appeared. I noticed them late one afternoon. They ran in a line from the side yard toward the lake, cutting across grass I had maintained for years. According to those stakes, more than 20 feet of what I believed was my property suddenly belonged on the other side of the boundary. I walked straight to the location where an old iron survey pin had always been visible near the tree line. It was gone. There was a fresh patch of disturbed dirt where it had been. That night, I went through the camera footage frame by frame. The camera covering the rear corner of the house had caught more than I expected. At 6:42 the previous morning, Mark walked toward the old iron pin with a shovel and another man beside him. The image was partially blocked by tree branches, but I could see them working near the marker. Several minutes later, Mark carried something metallic away from the spot. Later that same morning, a new orange stake appeared farther inside my yard. I watched the clip 3 times, then 5. I still did not know exactly what had happened, and I was not going to accuse anyone of something I could not prove. So I saved the footage. I copied it to an external drive. I uploaded another copy to cloud storage. Then I began photographing every marker, every disturbed patch of soil, every damaged plant, and every piece of equipment on the property. The next morning, the crew installed another section of dock frame. From my deck, I watched it extend farther over the water. The HOA had already announced a tentative opening date, less than 3 weeks away. That changed the urgency for me. If the dock opened, dozens of residents could begin walking through my yard and using that route as if it had always been public. The longer that continued, the more complicated the dispute could become. So I made a decision. I was done arguing. I was done trying to convince Linda. From that point forward, I wanted records, measurements, timestamps, permits, and documents. And before I went to bed that night, I checked the camera footage one more time. This time I noticed something I had missed. Linda was there that morning too. She stood several feet behind Mark while he worked near the old survey marker. And, at one point, she pointed directly at the ground, where the iron pin had been. The next morning, I stopped treating the situation like a neighborhood disagreement and started treating it like a file. I created a folder on my computer and gave every piece of evidence a date. Emails from Linda went into one section. HOA notices went into another. I saved the invoice for the supposed construction delays, screenshots from the neighborhood newsletter, photographs of the damaged dogwood, pictures of the removed fence, and every frame of video showing people entering my property. Then I built a timeline. The date Linda first asked to buy part of my shoreline. The date I refused. The first newsletter mentioning improved lake access. The first morning the construction crew entered my yard. The sheriff call. The new stakes. The missing iron pin. By the time I finished, what had felt chaotic started looking organized. And once it was organized, certain things stood out. Linda had repeatedly used words like access, community shoreline, and common area, but she had never once provided a recorded document proving any of them applied to my land. So I went to the county register of deeds. I started with my current deed, then pulled the deed from when my father owned the property. After that, I worked backward through earlier transfers until I had a chain of title reaching decades before Lake Briar Estates was developed. The language was old and technical, filled with bearings, distances, monument references, and descriptions tied to roads and water elevations that had changed over time. But one fact was easy to understand. My parcel existed before the subdivision. Next, I requested the original subdivision plat for Lake Briar Estates. I spread the copy across a table and compared it with the HOA map Linda had been using. They were not the same thing. The recorded plat showed the HOA common parcel ending before my boundary. The area where the crew had placed lumber and equipment was not marked as common property. I searched for easements next. If Linda was right, there should have been something recorded giving the association or its residents a right to cross my land. I found a utility easement. It ran along a completely different side of the property and existed for power infrastructure. I found drainage references. I found old right-of-way language near the road. What I did not find was a recreational easement leading through my backyard to the lake. That was the first moment I felt the balance beginning to shift. But I knew enough not to declare victory based on documents I did not fully understand. So, I hired Rebecca Shaw, a licensed land surveyor who had worked around the county for years. I gave her copies of everything I had found and told her I wanted an independent boundary survey. I did not tell her where I thought the line should be. I did not ask her to prove the HOA wrong. I asked her to tell me where my property ended. Rebecca spent the first visit locating surviving monuments. 2 old markers matched historical references closely enough to be useful. The third was the one near the tree line, the one that had disappeared. She studied the disturbed soil around the area, took measurements, recorded photographs, and compared the position with the old calls in the deed. Then she set up her equipment. I watched from several yards away while she worked through the bearings using survey-grade GPS and a total station. The first temporary marker she placed landed inside the construction area. Then another did too. She kept moving toward the lake. The reconstructed line did not follow the orange stakes the contractor had installed. It ran more than 20 feet farther toward the HOA side. In practical terms, the crew had not accidentally crossed the boundary by a foot or two. They had moved deep into my parcel. Rebecca told me not to rely on preliminary field marks until she completed the record research and calculations. That caution actually made me trust her more. While she continued working, I investigated the construction permit. The HOA had repeatedly claimed the dock was permitted, so I searched the county permit portal. At first, I thought I had missed it. There was no dock permit attached to my parcel number. I searched neighboring parcels. That was when I found one. A dock permit had been issued to Lake Briar Estates, but the parcel number belonged to the HOA common lot several hundred feet east of my property. The approved site plan placed the dock there, not behind my house. I checked the documents twice. Then I downloaded copies. The permit was real. The location they were building on was not the location the county had approved. That afternoon, I called a real estate attorney. After reviewing the deed, survey information, videos, HOA emails, and permit records, he told me to stop communicating casually with Linda or the contractor. From that point forward, everything needed to be documented. He sent a preservation notice instructing the HOA and contractor to retain emails, site plans, surveys, internal messages, contracts, and any communication about the dock location. Then he sent a formal demand that construction cease until the boundary and authorization issues were resolved. The HOA did not stop. Linda responded by dismissing my survey as biased because I was the one paying for it. She claimed the association had already reviewed the property line. My attorney asked for a copy of the survey they relied on. Nothing came back. He asked again. Still nothing. That silence told me almost as much as a document would have. Then, Rebecca called. She had gone deeper into the county archives because one of the older deed descriptions referenced a water boundary that did not match the current shoreline. She had located a recorded plat from 1968, years before the subdivision existed, and before several later changes around the reservoir. She told me she needed another day to verify the measurements. But before hanging up, she said something that changed the entire direction of the case. The HOA might not simply be wrong about where the property line crossed the grass. They might be wrong about where my property ended at the lake. Rebecca returned 2 days later with a rolled set of drawings under one arm and a folder thick enough to make me nervous. By then, The dock frame was already extending over the water, but the crew had slowed down after my attorney's letter. They were still showing up, still moving materials, still acting as if the project would eventually be completed, yet the confidence I had seen on the first morning was beginning to look more like stubbornness. Rebecca spread the documents across my dining table. The 1968 plat changed everything. The subdivision map Linda had relied on showed the modern shoreline as if it were a clean property boundary. The older recorded documents did not. My deed tied part of the boundary to historic monuments, bearings, and a water elevation that existed before later changes to the reservoir. That distinction mattered. Seasonal water coverage did not automatically turn privately owned land into HOA property. Portions of the ground near the present shoreline could be underwater at certain elevations and still remain inside the legal description of my parcel. Rebecca overlaid the old plat with the newer subdivision documents and her field measurements. The result was almost absurd. The HOA had been treating the visible edge of the water as though it marked the beginning of community property. It did not. My boundary extended farther toward the lake than Linda's map suggested, and the access route they were using crossed directly through my parcel. Rebecca completed the stamped survey and returned to the property to set new markers. One by one, bright survey flags appeared along the actual line. They cut straight through the contractor's staging area. They passed through the path where workers had been hauling lumber. They crossed the location of the steps leading toward the new dock. Most of the landward section of the structure sat on my property. This was no longer a dispute over a few inches. The construction had crossed the boundary by more than 20 feet in places. Then came the easement issue. My attorney ordered a deeper title search to make sure we were not missing some obscure recorded right from decades earlier. Nothing gave Lake Briar Estates residents the right to cross my backyard for recreational lake access. The only relevant easements on my parcel served utilities and infrastructure. The HOA did have legitimate lake access, just not through me. Their recorded common access tract was several hundred feet away. It was the same steep, rocky parcel that would have cost far more to develop. The cheaper route had been my land. That realization made Linda's earlier offer to buy a strip of shoreline look very different. She had known the association did not already own the easiest path. She had tried to acquire it. After I refused, the project somehow moved forward in the same location anyway. Then my attorney turned to the permit. The county records were even worse for the HOA than I had first realized. The permit itself was valid. The problem was the site. The application identified the HOA's common parcel to the east. The approved drawing placed the dock at that parcel. The contractor was required to build according to the approved location, but the structure behind my house was nowhere near it. In other words, they had not simply failed to obtain a permit. They had obtained permission for one location and built at another. That meant the document Linda had been waving around as proof of authority actually helped prove the opposite. The county had never approved construction on my parcel. My attorney packaged the deed, recorded plats, Rebecca's stamped survey, permit file photographs, and construction timeline into a formal submission to the county inspections department. Then he added the camera footage. I had watched the video so many times that every movement felt burned into my memory. Mark near the old iron marker, the disturbed soil, the object being carried away, the new stake appearing farther inside my yard, Linda standing nearby. Rebecca had independently documented physical disturbance at the old monument location before seeing the full footage. That connection made the evidence harder to dismiss as coincidence. We did not accuse anyone of a crime. We did not need to. We simply preserved the video, documented the site, and provided the material to the appropriate authorities. While that review was happening, Linda sent another message to residents. She portrayed the dispute as a technical boundary disagreement caused by outdated records. She suggested I was exploiting paperwork to delay an amenity that had already been approved for the neighborhood. That strategy might have worked before the survey. Now I had certified records. So, when Lake Briar Estates held an emergency board meeting, my attorney and I attended. I brought a copy of my deed. Rebecca brought the stamped survey. Linda brought the same enlarged GIS map she had used from the beginning. That was the moment I finally understood how much of her confidence had been built on something that was never designed to prove ownership. County GIS maps are useful for taxes and general parcel reference, but the boundary lines displayed online are approximate. The county's own system warned users not to rely on them as legal surveys. Linda had taken an approximate digital line and treated it like a deed. Rebecca's work was different. She had reconstructed the boundary using recorded instruments, physical monuments, historical plats, deed calls, and professional field measurements. The comparison was devastating. Board members who had supported the dock began asking questions. They wanted to know where the HOA's recorded easement was. There was none. They wanted to know why the permit listed a different parcel. No one had a good answer. They wanted to see the survey Linda claimed the association had relied upon before construction. No stamped survey appeared. Mark began distancing himself from the board. The board began distancing itself from Linda. What had once looked like a united HOA suddenly became several people trying to explain who had authorized what. Then, one of the board members asked for the original communications from before the project started. My attorney had already demanded those records be preserved. The room changed. For the first time since the crew entered my yard, Linda was no longer controlling the story. The deed controlled it. The survey controlled it. The permit controlled it. And the camera footage was waiting behind all three. I was still sitting in that meeting when my phone vibrated. An email had arrived from the county. I opened it beneath the table and read the first line twice. A site inspection had been completed. The construction location did not match the approved permit. A stop work order had been issued. The county inspector arrived the next morning just after 9. By then, the crew had already been told to stay off the site, but the unfinished dock was still sitting behind my house like a monument to everything that had gone wrong. Lumber extended over the water. Equipment remained parked near the access path, and the red survey flags Rebecca had placed made the boundary impossible to ignore. The inspector walked the site slowly. He checked the permit documents first. Then he checked the parcel number. Then, he compared the approved site plan with the structure in front of him. He did not need long. The permit location and the actual construction location did not match. The dock had been approved for the HOA common parcel several hundred feet away. What had been built behind my house was outside that approved site. The inspector attached a red stop work notice to the unfinished structure. For the first time since this started, the project was not paused because I objected. It was paused because the county had ordered it stopped. That distinction mattered. The HOA could ignore my emails. They could dismiss my deed. They could call my survey biased. They could tell residents I was being difficult. They could not talk their way around a county violation posted in red. The inspection triggered more questions. Code enforcement reviewed the grading around the shoreline, the disturbed vegetation, the access route used by equipment, and whether the contractor had authorization from the owner of the parcel where the work had occurred. That last question created a problem nobody on the HOA side could solve. I had never signed a site authorization. I had never granted construction access. I had never granted a temporary easement. I had never given the HOA permission to bring workers through my yard. My attorney followed immediately with a formal trespass and restoration demand. The association and contractor were told to remove stored materials, stop entering my parcel, preserve all evidence, and prepare to restore the property that had been disturbed. The damaged landscaping was documented. The missing fence section was documented. The cut dogwood branches were documented. The tire damage was documented. Every cost was starting to move from the category of neighborhood argument into the category of potential insurance claim. That was when the insurance companies appeared. Mark reported the incident to his contractor liability carrier. The HOA notified its own insurer. Before long, both carriers were requesting records, emails, contracts, board approvals, site plans, survey documents, communications between Linda and Mark, internal discussions about why the location had been selected. That changed the atmosphere almost overnight. Linda had been comfortable controlling what homeowners heard. Insurance investigators were different. They wanted documents, dates, and written authorization. They did not care who sounded more confident at a board meeting. The sheriff's office also followed up regarding the survey marker. A deputy contacted me and asked for the original camera files rather than the clips I had exported. I provided them. Rebecca gave a statement about the physical evidence she observed at the former monument location. I was careful not to speculate about intent. I only explained what the cameras showed, what had changed on the property, and when I noticed it. Whatever happened beyond that was for the authorities to decide. Meanwhile, The HOA scheduled another public meeting. That meeting was nothing like the earlier ones. Residents had begun asking why reserve money had been spent on a dock before ownership and access had been confirmed. They wanted to know who approved the final location. They wanted to know why the permit identified a different parcel. They wanted to know why the board had threatened me with fees when my property was not part of the association. For the first time, Linda was answering questions instead of making accusations. She tried to place responsibility on Mark. According to her version, the contractor was responsible for confirming field conditions and building at the proper site. Mark did not accept that. His attorney produced emails. One of them had been sent before construction started. In it, Mark had asked for confirmation that the HOA had legal control over the shoreline access strip because the location appeared close to a separately owned parcel. Linda had responded that the HOA had used the shoreline area for years and that the adjoining owner was unlikely to stop the project once construction was underway. That adjoining owner was me. The room went quiet when the email was read. Another message showed that Mark had asked whether a current boundary survey existed. He had never received one. Instead, the HOA had sent him the same GIS image Linda had been using from the beginning. Suddenly, everybody understood the problem. This had not happened because some invisible legal document had surprised the HOA. The warning signs had been there before the first piling went into the ground. The board had moved forward anyway. One board member asked Linda whether she had told them the property line had been professionally verified. Another asked whether she had authorized the contractor to use my yard. A third wanted to know why the board had not been told that I had previously refused an offer to sell the same waterfront strip. The unity disappeared. Linda tried to explain each decision separately, but every answer created another question. Then the HOA attorney, who had remained mostly silent, advised the board to stop discussing the facts publicly because insurance counsel was now involved. That sentence changed the entire room. This was no longer community politics. It was liability. By the end of the week, the unfinished dock was wrapped in caution tape. No workers were allowed to continue. The county case remained open. The insurers were exchanging documents. The sheriff had the original video files. My attorney had demanded restoration. And the board members who had once stood beside Linda were now communicating through counsel. I stood on my deck one evening and looked down at the red stop work notice moving slightly in the wind. For weeks, Linda had acted like authority came from a title. President, board, HOA. But once the county, lawyers, insurers, and official records entered the picture, titles stopped mattering. Evidence mattered, and the most damaging evidence had not even come from me. It had come from Linda's own email. The dock never opened. Within weeks, the HOA's insurer and the contractor's carrier were both involved in settlement discussions, and once the county records, Rebecca's stamped survey, the permit mismatch, the restoration costs, and the internal emails were all sitting in the same file, the argument became much harder for anyone to spin. The association agreed to remove every part of the structure that had been built on or accessed through my property. The lumber came out first, then the stairs, then the pilings. For several days, the same equipment that had entered my yard without permission was used to undo the project piece by piece. This time, the work happened under documented instructions, with the property line clearly marked and the county watching the restoration. The damaged section of fence was replaced. The ruts in the lawn were repaired. The landscaping stones were restored. The dogwood damage was included in the property claim. The HOA withdrew the invoice they had sent me for construction delays and formally acknowledged in writing that my parcel was not subject to their assessments or architectural rules. More importantly, they acknowledged that there was no recorded recreational easement through my backyard. That sentence mattered more to me than the money. It meant the dispute could not quietly reappear a year later under a different board member or a different project name. Mark and his company had their own problems to deal with through insurance and the licensing process. I was never given every detail of what happened on that side, and I did not need them. My goal had never been to destroy anyone's business. I wanted my land restored and the unauthorized construction gone. Linda's consequences were more public. The board that once followed her lead began distancing itself from her decisions. Residents had seen the emails. They had seen the stop work order. They had seen the dock torn back out. By the next election cycle, Linda was no longer HOA president. The new board adopted a requirement that future shoreline projects receive title review, permit verification, and a professional boundary survey before construction began. Their replacement dock, if they ever built one, would have to use land they actually controlled. Months later, I replaced the low fence near the tree line and added one small sign facing the neighborhood access path. Private property, please use HOA lake access. Nothing threatening, nothing dramatic, just accurate. The strangest part was how quiet the property felt afterward. For weeks, my mornings had started with emails, cameras, survey flags, phone calls, legal letters, and the sound of machines near the water. Then, one day, all of it was gone. I carried my father's old fishing chair down to the shoreline and set it near the place where the first piling had been driven. The grass was still recovering. There were fresh repairs along the fence. But the lake looked exactly the way I remembered it. And that was enough. I did not win because I yelled louder than Linda. I did not win because I threatened the board. I did not touch their equipment, damage their project, or try to embarrass anyone online. I kept the footage. I saved the emails. I checked the deed. I hired a surveyor. I found the permit. And when people with actual authority finally looked at the same evidence, the story changed. Property rights can look invisible until someone crosses the line. Then, every document matters. If you have ever had an HOA, neighbor, contractor, or developer act like confidence gave them ownership over your property, share your experience in the comments. Like the video if you want more stories about homeowners protecting their rights the legal way. Share it with someone who might need the reminder, save it for later, and subscribe to the channel for more property line, easement, permit, and HOA disputes where the paperwork ends up speaking louder than the people.